Dr. Makere is enrolled member of the Waiata Tai Whenua Kai Waitiki tribe in Aotearoa, New Zealand, has been actively engaged in issues related to globalization, Indigenous rights, and freshwater governance for over many decades. Makere is an expert member on a number of commissions for the International Union of the Conservation, including the Commission on Environmental, Economic, and Social Policy, Joint Specialist Group on Indigenous Peoples, Customary and Environmental Laws and Human Rights, and the Commission on Ecosystem Management. She is also a board member of the Keepers of the Water, NGO, Canada. She is a professor of Indigenous Environmental and Global Studies in the College of Social Sciences and Humanities at the University of Alberta Makere's engagement and research reflect her passion for and commitment to global transformation, climate change, freshwater protection and governance, multi-species justice, and our cohabitation of planet Earth. As the global society struggles to transition to new modes of coexistence, the contributions of Indigenous communities and Indigenous traditional knowledge systems are critical to this process. Her published work includes Troubled Waters, Maori Values and Ethics for Freshwater Management in New Zealand's Freshwater Crisis, Wires Water 2020, Resilient Systems, Resilient Communities 2018, Returning the Sacred, Indigenous Ontologies, Imperialist Times in Williams, Roberts, and McIntosh, Radical Human Ecology, Intercultural and Indigenous Approaches 2012, The New Imperial Order, Indigenous Response to Globalization. So without further ado, I'd like to welcome Whanua, our family in Maori, to share her presentation.
So I was muted in all of that. So I'll say that again. Okay, so I'm being, just a moment, please. I'm being asked to do something here. And I'm on a little laptop, so it's a wee bit limited. Let me just figure it out. So I was saying to thank Curtis for his very kind words, and that had I known that he was going to have to read all of that, I would have sent something much smaller. So the presenter view should give me the full slide, yes? But that's my presenter view, so this is not working. Somebody with technological skills, which defeat me still, please tell me what to do here. Let me go again, slideshow. But if I do presenter view, it gets me into trouble. Oh, there we go. Is that better?
Yep.
Thank you, everyone. So my apologies for all of that drama. So rivers and rights, you know, I want to preface this by saying, in addition to it being always an honor to talk about water and to do anything for keepers of the water, I really regret that I haven't been able to be online other than very briefly for 10 minutes yesterday. And so I have missed, I know, really wonderful presentations. But let me not waste too much time and let me go on here. So what I wanted to do today was really talk a little bit about the Whanganui River legislation to Awa Tupua in Aotearoa, New Zealand, primarily to just look at this question about the rights of rivers and to what extent that is a transformative approach to how we can protect our water. And so I wanted to begin by just mentioning a little bit about Indigenous worldviews, which set the scene for how we think about water in Aotearoa, New Zealand, and to just mention again that Indigenous people, certainly Māori and many others, regard the world in the sense of a very large cosmological, genealogical web in which we are all absolutely connected. And that for Māori, as for other Indigenous people, the fundamental principle that derives from that is the principle of relationship and also responsibility. And that with that responsibility is very much the ethic of taking care of the life force that is present in all things. So I wanted to mention that to just set the context for thinking about rivers and thinking about water. And so for Māori, which really is all I'm qualified to speak about, freshwater bodies are part and parcel of how we understand our identity. Our mountains, our rivers are very much part of who we are. So when we say to somebody, ko waikoe, who are you? We were asking the question, which water are you from? And so I've put up here a couple of sayings that express that. Ko te ukai po te whenua, ko te whenua te ukai po. The river is my, the land is my breast milk. The land is the river, I am the river, and the river is me. So very much that notion of who we are as people. And for rivers then, rivers are conceived of in their entirety. Rivers are conceived of as fundamental to the well-being of our communities, and that includes the entirety of the river from the mountains to the sea, the riverbanks, and all that is around that. Every water body has its own species, its own taniwha, spiritual beings that guard that water body, as well as all the other beings that are in that water body. And, you know, as Keepers always says, water is sacred, water is life. And for sure, for Māori, water has the ability to imbue other things and people with Māori, with the essence of sacredness itself. And so water is very sacred. So with all of that preamble, the Whanganui River legislation, which gave effect to the rights of the river as a person, has of course engendered a great deal of debate and interest over the years. And so the background to that is that it was part and parcel of the struggle over rights, customary rights, and treaty rights. And so it was the subject of a claim against the treaty between Māori and the Crown. We have only one treaty, the Treaty of Waitangi. And so the Whanganui River Act came out of that struggle and was a resolution as such of the claim against the Crown by the tribes that live along the Whanganui River. And it, as I've put up here on this slide, at issue where, of course, accessibility to the traditional waterway, but also ongoing issues around the degradation of fresh water, the diversion of fresh water, and all the things that go with that. So then in 2017, finally, well, 1999, they settled the claim, but in 2017, after years of negotiations, the Te Awa Tupua Act was signed between Māori and the Crown, represented by the New Zealand government, which gave effect to recognition of the relationship between Whanganui River tribes, and also declared the Whanganui River to be to have the rights of a person. So what does that actually mean? And you know, the fundamental question here that really I'm hoping that we can just think about is, what does it mean to give? What does it mean to give personhood rights to a river? And how effective is that? And to what extent can that really be a transformative tool when we look at how we can both effect rights and also protect the increasing, you know, the degradation of our rivers, which are increasing on a daily basis. So about the Whanganui River, it is the longest navigable river in Aotearoa, New Zealand. And the Te Awa Tupua Act did a number of things. So there are these two principles that recognised and promoted the health and well-being of the river, and its status as Te Awa Tupua, which is really about giving effect to the mana, the status of the river and its being as an ancestor, and also recognised the relationship between the iwi, the tribes, the Whanganui River tribes, and the river itself. So in conferring legal personhood on that river, it provided certainly a legal forum to formalise recognition of Māori cultural and spiritual principles and attitudes and that whole environmental system between Māori and the land and the river. So here are the details, or the kind of key details of that act. Let me just move that out of the way. Now, I hope you can read this. I know it's pretty small. So it recognises Te Awa Tupua as an indivisible and living whole. Okay. It refers to the Whanganui River from the mountains to the sea. And this is important. The language is important. So that's the reason I've got this here, is what does it say? It incorporates all its physical and metaphysical elements. Okay. Declares Te Awa Tupua to be a legal person with the rights, powers and duties, etc. of a legal person. And it provides for a form of trustees over the river's environment. So what it does is it establishes a trusteeship with two guardians, and one of those is representing the Crown, and the other is representing the iwi, or the tribes. So it also sets out a set of principles that the trustees need to abide by. And in principle, it provides, you know, a means of taking legislative action to protect the river. Here's what it excludes. It excludes any form of propriety rights. It excludes any ability to transfer propriety rights in the river water, including any of the things that live in the water. It excludes private property rights, and it excludes fishing rights, and it excludes any part of the river or the river bed that is within what is referred to as the Public Works Act. So there are some really important exclusions around the rights that accrue here. I'm just going to move over that because well, okay, I will go back to talking about this. And I know I'm going to badly mispronounce the real name of the Magpie River, so I won't endeavour to do that right now, but I just want to point to the fact that this is an interesting case because it is modelled on the Te Awa Tupua River. It is quite different in some ways, because this is a legal arrangement between the local body and the tribal councils or alliance, And it also has a range of resolutions which declare certain fundamental rights and established guardians to act on its behalf. The difference, I think, is that at this point in time, there's no provision within Canadian law for this notion of legal personhood for nature, but the rights that it is accrued to the river are also equally important. I'm sorry, this has kicked itself out, so sorry. Let me just go back. Not having a very good technological morning, I must say. Sorry about that. It just decided to reboot itself and do all sorts of mad things when I was trying to get on before. Okay. Questions that have been asked around the notion of the rights of the river include whether or not this is just a legal fiction, and some have argued that it is a legal fiction. The notion of nature as having rights and rivers as having rights has been described as a sleight of hand legal fiction by states to give the appearance of granting rights and protection to nature. So questions have been asked about to what extent is this emerging movement that has really, really taken off since 2017, and the first river, in fact, to be given legal rights was the river in Colombia in 2016. And others have followed suit since in India and other places. The question has been asked over and over again, to what extent is this a legal fiction, or to what extent is this a transformative approach, given the relationship between socio-economic and ecological systems that this all sits within. So to what extent then has the Whanganui River legislation enabled protection of the Whanganui River ecosystem? So there are some important things about that. 80% of the water in the Whanganui River is diverted by the hydroelectric company that has massive rights over the river. It's diverted into a lake, and then that is discharged back into the river, coupled with silt and various other things that accrue from the lake. There are a number of ongoing issues around that and the impact on freshwater fish in the river. The runoff from farms along the river is a massive issue in Aotearoa, New Zealand, as it is in southern Alberta here. And so the levels of fecal bacteria and E. coli render the river unswimmable in places. Rights of industry to discharge into the river still exist. So to what degree then can we say that that this has been an effective response, yes or no? With the settlement came a significant amount of money to engage in cleaning up the river. However, because of the circumscribed rights around water and the maintenance of propriety rights and property rights around the water, there are significant limits to how effective that can be. On the other hand, as we are seeing, this is really a growing movement, and as such, it's a very important movement. and especially in the current context of climate change. And I did just see the comment about the geese being very confused and not knowing whether to fly south or not. And certainly we are seeing these massive disruptions critically in rivers. And when we look at what just happened in BC, one of the things that I saw recently was the statement that the Fraser River, the lake adjacent to the Fraser River, had been drained and impacted. And one of the ongoing things that we're seeing is rivers reclaiming their space, rivers erupting in ways that speak to the ways in which we have diverted water and continue to divert water, the ways in which we have clear cut and all those other things, and the impact on rivers and water systems. So to what degree is this a transformative approach? And I did want to ask what people's thoughts were about that. I also have some notes here that I wanted to talk about, but given that this is the last session, and given that I've been having all of these issues, I'm not sure whether that's a good idea. But I would like some response to what your thoughts are about legal personhood rights and what we think personhood rights actually are. And I do have some comments that I would like to make about that, but I want first to ask what your thoughts are when we think about personhood and giving nature as such the rights of personhood. What does it mean to be a person? I can't see the screen because my little laptop is, the screen on my laptop is completely taken up, but there are some comments in the chat. Sherry, hi. Okay. So, sorry.
I guess because you can't see and somebody unmuted me because I was writing something there.
Right, no, I can't, that's right, sorry.
I like the idea that water has rights and water is life. But when I think about personhood, I guess we have to interpret it that way, but it's kind of leaning on human supremacy, and we have to get away from human supremacy because we're just one little thing in all of life. And it's good because the powers to be will only understand it in personhood, but I wish there was another way, and there is in everybody's own languages, but I just wanted to make that comment.
Thanks very much for that comment, and I see Jessie is saying that people can unmute if they would like to speak, and thank you for that, Jessie. You know, yes, and I want to go to the issue of the water itself. One of the questions that I think is really this raises in the limits around protection of the water is when we exclude the actual water from the rights of the river, what does that mean? And when is a river, and when is it not a river? Is it a river when its water is diverted and dried up? Is a really fundamental question that we are having to face more and more, especially as we see rivers increasingly being diverted for hydro or for various uses. And I'm thinking of the Murray-Darling River Basin in particular, but other places where the riverbeds dry up because they are so abstracted, especially for agriculture, right? And so when we think about legal rights of nature, which is a kind of an interesting term in itself, one of the things for Māori that I really want to go back to talk about or to sort of place here is the idea of when we talk about our responsibility as kaitiaki, so going back to that understanding of the cosmos and our relationship within that as being, yes, Diana, absolutely, in all its forms of life. Thank you. Exactly. And so when we go back to that genealogical relationship that we understand ourselves within, and the responsibility that accrues to that, which for Māori is very much about protecting the life force, the well-being of everything that is. Do the rights of the river extend to the plants, animals, insects, etc.? And that's the point. No, arguably yes, when we say, yes, this is a whole of river, all the things around it, but is that given effect in the legislation? And arguably yes, arguably that includes all the beings in the river. Arguably, from a Māori perspective, that includes all the non-human, non-physical beings, and I'm thinking of the taniwha, the guardians of the river, the spirits of the river, that we don't see but that we know are there. So the arguments that go around this in legal, documents, etc., are very interesting, because they range from this kind of argument. Well, one of the arguments that they talk about is the human rights of Indigenous communities to access and protect the river. So that's a human rights argument. Then there is the argument that these are legal fictions created by states to give the appearance of resolving or resolution or reconciliation around particular issues. In this case, it was a treaty settlement. So this idea of a fiction created to give the appearance of reconciliation. But others are pointing out, and I think this is important, and of course we know this really, that legislation of any kind, whether it is the rights to nature, whether it is, the rights of rivers, the rights of water, etc., is only effective to the extent that it is enforceable. And so when we engage in this kind of jurisprudence, when we engage in activities which are the pursuit of the rights, the rights of nature, which we should, then what are the mechanisms by which we can ensure that there is a framework that provides enforceability? And one of the things that we rub up against right there is existing propriety rights in the river. For instance, hydro companies and others who draw on farming. The farming lobby is an enormously powerful group in Aotearoa, New Zealand. So agriculture and farming, others here, a lot of abstraction also is around oil development and so forth. So yeah, for sure. Absolutely, Amy. Yeah. On that, I'm reminded of, and I've seen it here too, that the importance of that ceremony, the importance of that speaking to the river, of the importance of thinking the river, or whatever it is that we're disturbing at the time. But when we are thinking about how can we protect nature through jurisprudence like the rights of rivers, arguably, as has been done elsewhere, we need to go beyond personhood and legal rights of personhood to a vision of rights that gives rights to multiple species, multi-species rights. Yeah, thanks, Sherry. That's, I think, in the time that we have,